And hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. For our regular Friday night hangout, I'm happy that you're here, and hopefully today is the day I earn that subscription. For our Friday hangout, we will be doing a recently released memo from the Attorney General Barr administration. This is a 2019 memo that related to the decision on whether or not to prosecute Trump in relation to the Mueller report, specifically as it relates to potential charges of obstruction of justice. And there was a memo that was prepared for the Attorney General describing why they should or should not prosecute Trump in relation to this. Now, a previous version of this memo was released, but only in redacted form. Recently, a federal judge ordered that the entire memo in its unredacted form be released. So this only happened a couple days ago. This unredacted memo got released, and I thought we would cover it together. Also, because it's Friday, if for every $100 worth of super chat you collectively donate, I will take a shot. So you don't have to donate it all yourself. For every $100 that's collectively donated by the chat at large, I will take a shot, and we will do that together as we learn from things relating to the Trump administration. So let's go ahead and do that. So this is a memo that was prepared for the Attorney General through the Deputy Attorney General, as we can see. This is from the Assistant Attorney General in the Office of Legal Counsel and the Principal Associate Deputy Attorney General in relation to review of the special counsel, that is the Mueller's report. Let's go ahead and get started with this. At your request, we evaluated Volume 2 of the special counsel's report on the investigation into Russian interference in the 2016 presidential election to determine whether the facts recited therein would support initiating or declining the prosecution of the president for obstruction of justice under the principles of federal prosecution without regard to any constitutional barrier to such prosecution under Article 2 of the Constitution. So one of the first things you might want to know is, wait a second, is there a constitutional problem with this? Because all the executive power belongs to the president, and you're prosecuting him for things that he did potentially while president. So you might run this situation where he's prosecuting himself. So you run into some issues there, but this memo is going to look past that issue and just deal with concerns outside of that. Fine. Over the course of the special counsel's investigation, we've previously determined these issues within the department ourselves, with the Deputy Attorney General, and with you, since your appointment, as well as the special counsel and his staff. Our conclusions are the product of those discussions, as well as the review of our report. Exciting and fun. For the reasons below, we conclude the evidence described below in Volume 2 of the report is not, in our judgment, sufficient to support a conclusion beyond reasonable doubt the president violated the obstruction of justice statutes. In addition, we believe that certain of the conduct examined by the special counsel could not, as a matter of law, support an obstruction charge under the circumstances. Accordingly, were there no constitutional barrier, we would recommend, under the principles of federal prosecution, that you decline to commence. So again, this memo does not attempt to analyze the constitutional issues. It says, okay, well, whether or not there's a constitutional barrier or not, we're still not going to recommend prosecution. Fine, let's go ahead and do that. I miss the cowboy hat too. The cowboy hat is at home, but we'll be reunited with it soon enough. Okay. The department should reach a conclusion on whether prosecution is warranted based on the findings in Volume 2 of the special counsel's report. The special counsel has investigated certain findings relating to the president's response to the FBI Russia investigation and the subsequent special counsel investigation. In doing so, the special counsel reached no conclusion as to whether the president had violated any criminal law or whether, if so, such conduct warranted prosecution. The special counsel considered evaluating such conduct under Justice Manual standards governing prosecutions and declarations, but determined not to apply that approach for several reasons. The special counsel recognized the Office of Legal Counsel had determined that a sitting president is constitutionally immune from indictment and criminal prosecution. And so that is one of the problems because, well, the president has all the executive power, as Article 2 seems to say. And so can you prosecute the president while he's sitting? That doesn't seem to really make sense because you're prosecuting yourself. And what does that even mean? Right? So there's some problems there. Although the OLC, the Office of Legal Counsel opinion, permitted the investigation of the sitting president, which, fair enough, the special counsel concluded that it would be unfair to reach any charging decision because the president would not then be afforded any opportunity to clear his name before an impartial adjudicator. So one of the concerns of the special counsel is, well, I don't want to reach the determination of whether or not he should be prosecuted or not, like in principle, because if I reach the conclusion he should, but we can't because of these constitutional concerns, then there's no neutral arbiter, right? We're not prosecuting for technical reasons, and his name is besmirched. So we shouldn't do that. Okay. Accordingly, the review identifies evidence on both sides of obstruction question and leaves unresolved what it reviews as difficult issues concerning whether the president's actions and intent could be viewed as obstruction of justice. Not for at least the reasons, as I'm sure this memo will get into, the president has the right to command his subordinates, which includes the Attorney General, which includes the FBI. I mean, the FBI is part of the executive branch. It's part of him. And so he has the right to... So it's not even clear that the president can obstruct justice because all the law enforcement mechanism works for him in the first place. So, he's just making a decision as a superior. So, it doesn't quite maybe make sense to talk about obstruction of justice. Although the special counsel has declined to reach a conclusion, we think the department should reach a judgment in this matter. Under traditional principles of prosecution, the department either brings charges or it does not. Because the department brings charges against an individual only, where admissible evidence would support proof of such charges beyond a reasonable doubt, that is standard Department of Justice language. At least the Department of Justice does not bring charges unless they believe they can get to proof beyond a reasonable doubt. That isn't necessarily the requirement to bring charges, right? You only have to have preponderance of the evidence on a prima facie case. But the Department of Justice, as a matter of its own policy, doesn't prosecute unless it believes at the outset it can get to proof beyond a reasonable doubt. So it doesn't go fishing, in other words, and that is longstanding Department of Justice policy. It's one of the reasons the Department of Justice has such a massively high conviction rate, because it tends to only prosecute in cases where it's absolutely clear, at least in their view. That doesn't mean that they don't lose. They do sometimes, but they at least subjectively believe they can get there. In any case, any uncertainty concerning the facts or law underlying a proposed prosecution ultimately must be resolved in favor of the individual. Yes. That principle does not change simply because the subject of the investigation is the president. Although the special counsel recognized that unfairness of levying an accusation against the president without bringing criminal charges, the report's failure to take a position on matters described therein might be read to imply such an accusation if the confidential report were released to the public. Therefore, we recommend that you examine the report to determine whether prosecution would be appropriate given the evidence recounted in special counsel's report, the underlying law, and the traditional principles of federal prosecution. Okay, fair enough. Okay, yeah. Hamilton says, respectfully, the president can and did obstruct justice. Mueller testified before this in front of Congress. The laws apply the same to the president for which he could be tried one of office. No, that's not all clear, in my opinion. It's not clear that the president's actions legally are the obstruction of justice, because the president can give an order to the Attorney General, because the Attorney General works for him. He can give an order to not prosecute, right? Because he outranks the Attorney General. So it's not at all clear that the president saying to do something or not do something legally can be obstruction for those reasons, because the president is the chief executive. He has all the executive power according to Article 2. So that's the reason why it's not clear the president can legally obstruct. A fair evaluation of the special counsel's findings and theories weighs in favor of declining prosecution. While cataloging actions the president took, many of which took place in public view, the report identifies no actions that, in our judgment, constitute obstructive actions done with a nexus to a pending proceeding. with the corrupt intent necessary to warrant prosecution under obstruction of justice. Based on evidence described and legal theories articulated in Volume 2 of the Special Counsel's Report regarding whether the President has obstructed justice in connection with the Russia-related investigations, we believe the prosecution will not be warranted in these circumstances wholly apart from constitutional considerations. The applicable principles of federal prosecution articulated in the Justice Manual state a determination to prosecute represents a policy judgment. The fundamental interests of society require the application of federal criminal law to a particular set of circumstances, recognizing both the serious violations of federal law must be prosecuted and that prosecution entails profound consequences for the accused, crime victims, and their families, whether or not a conviction ultimately arises. The stated principles advance two important purposes: ensuring fair and effective exercise of prosecutorial discretion and responsibility by attorneys for the government, and promoting confidence on the part of the public and individual defendants that important prosecutorial discretions will be made rationally and objectively based on the merits of the case. Yeah, we're all waiting to see the Trevor Summers verdict come down. I would imagine there's a verdict coming day. This is the pro se that decided to fire his attorney and represent himself in the alleged kidnapping, attempted murder, and sexual assault of his ex-wife. His cross-examination seemed to expose him in his own closing, seemed to reveal the reasons why he should be convicted. I came into his closing argument with more doubts as to whether he should be convicted of attempted murder than when I left. When your own closing narrows the scope of doubt, things are not going well for the defense. So that will be entertaining when that drops, I'm sure. These principles must be applied by the department to all prosecution decisions, no matter the status or the subjects of the target of the investigation. The Justice Manual instructs that as a threshold matter, a prosecutor should only commence or recommend federal prosecution if he or she believes the person's conduct constitutes a federal offense and admissible evidence will probably be sufficient to obtain and sustain a conviction. The comment to this section further clarifies, both as a matter of fundamental fairness and the interest of efficient administration of justice, no prosecution should be initiated against any person unless the attorney for the government believes that admissible evidence is sufficient to obtain and sustain a guilty verdict by an unbiased trier of fact. If these threshold factors are satisfied, the prosecution should then weigh other relevant considerations in deciding whether to commence or recommend the prosecution. So, as always, prosecutorial discretion is a thing. Just because we can convict doesn't necessarily mean we should even try, for a lot of potentially valid prudential reasons. Applying these principles, if a person's conduct under scrutiny is not a federal offense or admissible offense is not sufficient to obtain a guilty verdict, prosecution should be declined. Okay. To our knowledge, the special counsel's investigation of potential obstruction is not similar to any reported case the department has previously charged under obstruction of justice statutes. The report identifies no obstruction case the department has pursued under remotely similar circumstances, and we have not identified any either. Of course, any investigation concerning the president would be exceptional, but the president is hardly the only public official who could be subject to investigation. The department has investigated potential misuse of official authority, including obstruction of official proceedings, in a host of different circumstances. The special counsel's obstruction theory would not only be novel, but based on his own analysis, it would also be unusual because Volume 1 of the special counsel's report is conclusive. The evidence developed was not sufficient to charge that any member of the Trump campaign, including the president, conspired or coordinated with representatives of the Russian government to interfere in the 2016 campaign. Given that conclusion, the evidence does not establish a crime or criminal conspiracy involving the president, towards which any obstruction or attempted obstruction prosecution that itself did not arise out of prosecution proceedings relating to a separate crime. Moreover, Moreover, much of which the president potentially obstructive conduct amounts to attempt to modify the process under which the special counsel investigating progressed, rather than efforts to impair or intentionally alter evidence, documenting, or testimony that would negatively impact the special counsel's ability to develop evidence. So one of the things they're saying here is that there is apparently no underlying crime, right? So the idea here is that in most obstruction cases, if not all obstruction cases, because they seem to be having a problem finding any precedent to the contrary, apparently in all obstruction cases, there's some underlying crime they're trying to obstruct, right? Which makes sense. Like you're trying to prevent them from finding the evidence relating to the whatever crime. And so you're obstructing that investigation. But one of the things they're saying here is that there is no evidence of a crime or criminal conspiracy involving the president to which the obstruction would be directed. So he's obstructing an investigation into nothing. And so that presents potentially an unusual circumstance, right? There's no underlying crime he's trying to obstruct the investigation of. So that would be different, according to them. That's what they're talking about. The special counsel's report cites over a dozen federal obstruction decisions in the report, yet nearly every one, the charged conduct involved inherently wrongful acts to destroy evidence, to create false evidence, or tamper with witness or jurors, and an effort to prevent the investigation or punishment of a separate underlying crime. So that's, this separate underlying crime seems to be one of the big factors here. We have identified only two cases that lack one of these elements. The first is Arthur versus United States, which concerned the destruction of evidence in advance of an expected SEC investigation. Although there was no evidence in the case of an underlying crime, the exception essentially proved the rule, because the United States Supreme Court vacated the conviction precisely because the prosecution could have covered innocuous conduct. When it comes to actions otherwise lawful in themselves, the court emphasized the need to exercise restraint in assessing the reach of a federal criminal statute, because the need to provide fair warning. The court emphasized such restraint is particularly appropriate where the act underlying the conviction is itself innocuous, is not inherently malignant, and could be performed for appropriate non-criminal reasons. So you're obstructing investigation into something lawful. Basically, the Supreme Court's talking about. In construing the obstruction statute, the Supreme Court observed that corrupt and corruptly are normally associated with wrongful, immoral, depraved, or evil conduct, and the court vacated the conviction because the jury instruction did not meet that demanding standard. In relation to your question about why they're releasing this memo, a judge ordered them to. I'm not precisely sure about the context of it, but a federal judge ordered the release of the memo. So that's why this memo is being released at this time, because they were just directed to by a court. In our prior decision, the special counsel has acknowledged that we've not uncovered reported cases that involve precisely analogous conduct. Indeed, in seeking to identify cases in which misuse of otherwise lawful authority established an obstruction case, the memorandum cited 3 charging documents, 2 of which arose from state court and thus did not arise to a federal criminal violation. So this seems to be fairly few and in between, if it happens at all. All 3 cases involved an effort to use official authority to prevent prosecution or punishment of distinct crimes. The one federal case did not involve just the abuse of official authority, but rather witness tampering and manufacturing of false evidence, concerns that go to the heart of obstruction. Accordingly, there simply does not appear to be any clear legal precedent similar to the kind of conduct that is demonstrated here. We have carefully reviewed Volume 2 of the report and concluded it does not identify sufficient evidence to prove any criminal offense beyond a reasonable doubt. Although Volume 2 makes no conclusions about the president's conduct, it adopts an expansive reading of 28 U.S.C. 1512c2 as prohibiting any act, including an otherwise lawful act, that impedes an official proceeding, so long as it's done with corrupt intent. According to the special counsel, There's no requirement that the act be inherently malign or impair the availability of witnesses or evidence. At the same time, the report advances several definitions of corruptly, including one that would establish intent by proof of improper purpose. The report thus suggests the president's exercise of executive discretion for any improper reason, including the prevention of personal embarrassment, could constitute obstruction of justice if it impeded a pending investigation. As we discussed with you, we do not subscribe to such a reading of the obstruction of justice statute. No reported case comes close to upholding a conviction of such breadth, and in line of Supreme Court precedent, including the Arthur Anderson decision, weighs heavily in favor of objectively and certainly in federal law. In order to reach a conclusion in this memorandum, however, we do not believe it necessary to address this disagreement further because, in our view, Volume 2 of the report does not establish offenses that will warrant prosecution even under such a broad legal framework. So even if we could get past all that issues, we would still have problems. The report evaluates 10 episodes involving president's conduct. For many of these episodes, the special counsel advises there is significant evidence to indicate the president's actions would not meet one or more of the elements of obstruction of justice. For others, the special counsel's evaluation of the evidence is more equivocal, and he identifies evidence on both sides of the question. How we review the report in the light of governing legal principles and the principles of federal prosecution, we conclude that none of these instances would warrant prosecution for obstruction of justice, without regard to constitutional constraint on bringing such action. Having discussed each of these episodes with you on multiple occasions, this memorandum summarizes the reasons for our conclusions without analyzing each and every element in the report. It was apparently in response to a Freedom of Information Act request for Citizens for Ethics Watchdog. So that's how it came to be, as responsive of a FOIA, which makes sense. I mean, it's no longer relating to an ongoing investigation. But it is internal deliberative processes, but I'll let the FOIA lawyers figure it out. We do not believe any of these events establishes obstruction of justice. As the report indicates, during this period, the president was repeatedly informed by Comey that he was not personally under investigation. There's no evidence that the president knew of Flynn's conversation with Kislyak or had misrepresented to the vice president prior to McGahn informing him of these facts. At the same time, the president repeatedly demonstrated his belief that the Russian investigation cast a cloud on the nascent administration and was being exploited, if not outright conducted, by his political opponents to frustrate his efforts to implement his agenda. As the report indicates, many of the president's actions in these matters can readily be explained by his desire to have the FBI director or others in the administration inform the public that he was not under investigation. Indeed, the report identifies substantial evidence the FBI director's refusal to make such public statements was a driving force in the president terminating him. We also do not believe the president's actions regarding Michael Flynn present any case of obstruction. The special counsel did not uncover any evidence the president had personal culpability in the Flynn investigation or that his actions were motivated by improper considerations. The president's expression of hope that Comey would let him go does not clearly direct a particular action in the Flynn investigation, and Comey did not react at the time as though he had received a direct order from the president. By the same token, as the special counsel acknowledges, the president's decision to remove the FBI director does not constitute obstruction either. In our view, none of these actions constitute a case of obstruction either as a matter of law or as a matter of fact. The report also discusses a second category of actions taken by the president after appointment of special counsel, most notably after he learned the special counsel had opened an investigation into potential obstruction of justice. Most of the conduct identified consists of facially lawful actions that are part of the president's constitutional responsibility to supervise the executive branch. The special counsel considers, for example, whether the president's obstructed justice by asking the White House counsel to direct the firing of special counsel, by asking Corey Lewandowski to contact the Attorney General and seek his assistance in narrowing the special counsel's investigation, and by asking the Attorney General to reverse his recusal and supervise the special counsel's investigation. We do not believe the principles of federal prosecution support charges based upon any of these actions. As noted, the evidence does not establish the president took any of these actions because he sought to prevent the investigation of an underlying criminal offense, separated and apart from the obstruction case. And the department rarely brings obstruction cases absent several criminal offense. I mean, that does seem to be true based on their own descriptions. Seems like they don't really do this. Such prosecution is doubly inappropriate, whereas here the conduct under investigation is lawful in its face, and evidence of any corrupt motives is, at the very least, questionable. Federal criminal statutes should be construed to avoid criminalizing generally innocent conduct. The standard for demonstrating a public official acted with corrupt intent is demanding, and there's considerable intent to suggest the president took these official actions not for a legal purpose, but rather because he believed the investigation was politically motivated and undermined his administration's efforts to govern. Moreover, in the evaluating the nature of the president's conduct, it bears emphasis that none of his requests to change the supervision of the investigation were actually carried out. The conduct under investigation is based entirely upon decisions by the president to subordinates to take actions on his behalf that they did not undertake. In each instance, if the president truly wanted to cause those actions, he could have done it himself. For instance, ordering the Deputy Attorney General to terminate the special counsel, or directing the Attorney General to unrecuse or resign. After the president provided his direction in each instance, the orders were not carried out. Of course, it's true that an act may constitute an attempt or an endeavor, even if unsuccessful. But the fact that the president could have given those directions himself and did not remove any subordinate for failing to carry out his directions weighs against him finding to impact and obstruct justice. The special counsel's report also describes a variety of other actions taken by the president that could have some effect on potential witnesses of an investigation. Those actions include the president's public and private comments concerning the recollections and testimony of potential witnesses, including the president's efforts to encourage the White House counsel, Don McGahn, to deny a newspaper report the president had directed McGahn to fire the special counsel, his involvement in responding to media interest in Trump Tower meeting, and his public and private comments concerning witnesses who appeared to praise or condemn based on whether they were fighting the charges against them or cooperating. The president's actions on these matters more directly implicate the concerns of obstruction statute. If the president were to perjure himself, tamper with witness testimony, or corruptly destroy evidence, such actions would violate well-established law. But we do not believe that any of the actions described in this report would meet this standard. Yeah, so no perjury, no tampering, no destruction of evidence. Okay. None of these instances indicate the president sought to conceal evidence of criminal conduct, nor is there sufficient evidence to prove beyond a reasonable doubt he sought to provide false evidence to investigators. For instance, when it comes to the president's request that McGahn deny the newspaper accounts, the special counsel recognizes there's evidence suggesting the president believed the newspaper stories to be false. The president repeatedly protested both to McGahn and other witnesses that he believed that he had asked McGahn to advise the Deputy Attorney General about the special counsel's conflicts of interest and thereby induce the appointment of unconflicted special counsel. The president vehemently denied telling McGahn that he wanted to fire the special counsel, and McGahn recalled the president's direction to be more ambiguous. While other evidence cuts against this understanding, there's insufficient understanding to conclude beyond a reasonable doubt that the president sought McGahn to lie. In addition, at the time of the discussion, McGahn had already provided his recollection to investigators, and the president's principal focus was on rebutting the media reports. Given timing of this conversation, there's insufficient evidence to conclude the president's actions towards McGahn, which were themselves ambiguous, were intended to affect the investigation itself. Therefore, the evidence in our judgment is not sufficient to warrant criminal prosecution. So, again, the president's words seem to be ambiguous. They seem to be open to a lot of interpretation. It doesn't appear that the subordinates are taking directions based on these vague wishes. It's not related to an underlying crime. So there's a lot of sort of benchmarks here that seem like they are reasonable, at least on some level. Yeah. We likewise do not believe the president's public statements extorting witnesses like Flynn, Manafort, Stone, or Cohen not to flip should be viewed as obstruction. The report makes clear the president equated a witness's decision to flip with being induced by prosecutors to manufacture false evidence against others. We cannot say the evidence would prove beyond a reasonable doubt the president's statements, most of which were made publicly, were intended to induce any of those witnesses to conceal truthful evidence or provide false evidence. Once again, this conclusion is buttressed by the absence of any clear evidence these witnesses had information that would prove the president had committed a crime. The president's public statements could be viewed as efforts to defend himself from public criticism related to a special counsel investigation, or discourage the witnesses from making what the president believed might be false statements in exchange for lesser sentences. These statements do not warrant prosecution for obstruction of justice. And John O'Brien says the argument is it's too tenuous to establish a crime. That's basically it. Yeah, in so many words. It's just too tenuous. It's too thin. He's making these statements publicly. He seems to believe they're false. He seems to be expressing wishes. People aren't acting on it. He's not making direct orders. He's not firing people. He's not restoring evidence. There's no underlying crime. There's also constitutional concerns, which this memo doesn't get into. So there's a lot of issues here. So this memo at least makes sense. I mean, someone could probably write a different memo that says different things, but this memo makes sense to me at least. So I got that going for it. Although we've not identified any actions that present clear violations of obstruction of justice, there are other factors that would weigh against pursuing the president's actions as criminal. The special counsel's thorough investigation did not establish the president committed any underlying crime related to Russia interference. As noted in every successful obstruction case cited in the report, corrupt acts were ultimately taken to prevent the investigation and prevention of a separate crime. The existence of such an offense is not a necessary element to proving an obstruction charge, but the absence of underlying guilt is relevant and powerful evidence in assessing whether otherwise innocent actions were undertaken with a corrupt motive. In the absence of an underlying offense, the most compelling inference in evaluating the president's conduct was that he reasonably believed the special counsel's investigation was interfering with his governing agenda. Even if the president were objectively wrong about the intentions of the special counsel, many, if not all of his actions could be viewed as lacking intent element under relevant statutes. In addition, why our analysis would counsel against pursuing an obstruction charge against an ordinary party in the absence of an effort to impair evidence? There are additional prudential reasons that weigh against such an interpretation in these circumstances. Such a criminal prosecution would involve the application of a novel obstruction theory that arguably would apply to any official whose authority to take acts could influence an investigation. That's part of the problem there, sure. Such an extension would involve serious questions about public policy and constitutional law that would weigh against pursuing criminal charges except under the clearest of cases. Therefore, we recommend that you conclude that under the principles of federal prosecution, the evidence deployed during the special counsel's investigation is not sufficient to establish the elements of the offense. Well, I mean, I find that memo to be fairly persuasive. And again, someone could write a different memo, but I find that argument to be fairly persuasive. That the president's making a lot of these statements out in the open. No one seems to be acting on them. No one seems to be doing anything. They're not very clear on their face. He's not firing anyone. He's not doing that. And even if he was, you run into questions about whether he could do it anyway. So there's all kinds of problems all over the place. So, it's not going to convince the detractors of the president. It's not going to convince the detractors of the bar. But, I find the memo to be overall very, very persuasive. It's this is just, and to the extent they're right, that all the examples were in concealment of underlying crimes, and they found one U.S. Supreme Court case where the charges were reversed because there was no underlying crime. There seems to be a lot of reasons to go this way. So I find the memo to be fairly persuasive. So that's basically all I have for today. So that is the end of our Friday Night Live. I hope you enjoyed this stream. I enjoyed this stream. I hope, that you found something of value out of it as well. So I'm going to go ahead and wrap the stream up. If you've been enjoying the stream, please remember to do all the YouTube things. Like, comment, subscribe. Make sure to join as a member, help to support the channel, all the rest of it. Thank you to the 188 of you who have been with us and viewing this. I hope you found it informative. And until later, my friends, I hope all's well. Cheers, my friends, and goodbye.